Hi there, thank you for coming today. So I'm going to be looking at a couple of European Court of Justice decisions that have taken place in the European Union in 2014, which was certainly a year of contradictions from the approach that they took. The first two cases I'm going to look at are copyright cases in the online environment, and the third case concerns database rights, which is an unusual right protecting databases within the 28 member states of the European Union. The first case I'm going to look at is the case of XVIII, where the Court of Justice of the European Union delivered its judgment in a landmark decision about copyright infringement on the internet. The CJEU, in that case, ruled that the owner of a website may use hyperlinks to redirect internet users to protected works available on other websites without the authorization of the copyright holder of the linked website, provided that the linked website is freely available, i.e. that it can be accessed by anyone on the internet. So let's have a look at the background to that case. So in this case, the website was the XVIII website, which operated providing links clickable to articles published by other websites on the internet. The claimants were journalists who wrote articles for the Göteborgs Posten website, and those articles were being linked by the XVIII website. The claimants argued that the XVIII hyperlinks constituted an infringement of the claimant's copyright by making a communication to the public without the author's permission, and they alleged that this was contrary to Article 3 of the Information Society Services Directive, commonly known as the InfoSoc Directive, which is the European directive which harmonizes copyright across the 28 member states of the European Union within the Information Society. The case made its way to the Swedish Court of Appeal, which stayed the proceedings pending a reference of 4 questions to the Court of Justice of the European Union. So let's have a look at those 4 questions. Question number 1 was that if anyone other than the holder of copyright in a certain work provides a clickable link to the work on his website, does that constitute a communication to the public within the meaning of Article 3.1 of the InfoSoc Directive? Question 2 took the question a stage further, asking whether or not if the assessment under question 1 is affected, if the work to which the link refers to on a website on which the internet can be accessed by anyone without restrictions, or if its access is restricted in some way. The third question asked that whether, when making the assessment under question 1, should any distinction be drawn between a case where a work, after the user has clicked on a link, is shown on another website, or one where the user has clicked on the link and is shown in such a way as to give the impression that the content is appearing on that website, in other words, framing the content. So if you click on the link and it doesn't take you to the other person's website, but it actually just brings up a frame on your website, which makes it appear that the content is part of your website. And the fourth question asks whether or not it's possible for a member state to give wider protection to the author's exclusive rights by enabling communication to the public to cover a greater range of acts than that actually expressly provided for in the InfoSoc Directive. So in answer to the first question, the Court of Justice determined that a communication to the public requires both a communication and a public. The hyperlinks were determined to be making available, and therefore they were an act of communication. However, there's a sting in the tail, because the Court of Justice held that the public must be a new public. In other words, the communication must be directed to a new public, a public that wasn't taken into account by the copyright holders when they first authorized their initial communication to the public. In the circumstances of XVIII, the public targeted by the journalist's original articles consisted of all potential visitors to the Göteborgs Posten website, which was unrestricted, and therefore they could be freely viewed and read by any internet user. Consequently, the links provided by the XVIII website were not a new public, and there was no need to obtain the author's consent. In response to the second question, the situation would be different if the link allowed users to bypass restrictions designed to limit access to the public, such as a paywall, as can be found on the Times of London website or the Wall Street Journal website and many others. such users were not taken into account by the original copyright holders when the initial communication was authorized. So those people would constitute a new public. Regarding the third question and framing, the Court of Justice unusually held that it was irrelevant that an internet user who clicks on a hyperlink is given the impression that the linked work is appearing on the site that contains the link. In other words, framing somebody else's content that's already freely available on the internet on your own website is absolutely fine. And there are obviously issues that arise out of that concerning advertising revenue streams that some people have on their websites, where they are effectively making money by putting content freely on the internet, by having advertising revenue surrounding their content. But of course, if somebody can freely embed that content on their website, those adverts aren't necessarily seen. But as far as the European Court of Justice is concerned in the context of copyright, that's perfectly acceptable. And this applies across all 28 EU member states. In answering the fourth question, the CJEU held that member states do not have the right to give wider protection to copyright holders by widening the concept of communication to the public from that's contained in the Information Society Services Directive, as this would otherwise give rise to legislative differences between member states contrary to the purpose of the directive. Following hot on the heels of the Svensson decision was the Bestwater ruling. Now the Bestwater case has reconfirmed the liberal approach that the Court of Justice takes towards embedding copyright material and copyright protected material on a third-party website. The Bestwater case has actually been stayed pending the outcome and decision handed down in the Svensson case. The CJEU, the Court of Justice of the European Union, has ruled that unless an original publisher uses technical access restrictions, then embedded content does not reach a new public. The effect of this judgment, combined with the Svensson judgment, is likely to lead to more restrictive publishing practices within the European Union, as copyright holders will seek to avoid free riders taking advantage of the loophole the court seems to have legitimised. So by way of background, the Bestwater case was referred to the Court of Justice by the German Federal Court of Justice. It deals with a promotional video about water pollution that was produced by Bestwater International, a company that makes water filters. The film was originally published by Bestwater on its own company website and was later uploaded onto YouTube, allegedly without the permission or knowledge of Bestwater. The defendants here in this case were two sales representatives of a competitor of Bestwater, and they embedded the video on their websites with the frames pointing to the YouTube uploaded copy. Now, Bestwater objected to this use and sought an injunction against, not YouTube, but against the two representatives of the rival company from the German court. Bestwater's position was that the video was protected by copyright, and that the exclusive rights to use the film belong to Bestwater. So as I say, the German court referred the case to the Court of Justice of the European Union, asking whether the embedding of content of a third-party website on one's own website constitutes communication to the public within the meaning of Article 3 of the InfoSoc Directive. After the Svensson decision, the Court of Justice felt that it had already put an end to the debate of embedded content on the internet, and it actually reverted back to the German courts, suggesting that the German court should withdraw its submission. In other words, the European Court of Justice didn't want to give an answer. It said that we've already answered this. But the German court insisted on a decision, one of the main reasons apparently being because in this Bestwater case, the YouTube video which the defendants were linking to and embedding on their website was of itself a copyright violation. Nevertheless, in delivering its decision, the Court of Justice of the European Union followed the same rationale as in Svensson and held that embedding content from another website does not communicate a communication to the public if the uploader did not restrict access to the content and communicated it to the entire internet community. there was no new public accessing the Bestwater video when it was embedded on the defendant's website, because when the video was uploaded on YouTube, whether that be lawfully or unlawfully, it was intended to be accessed by all who have access to the internet. So this ruling somewhat cast doubt on the technical and economic understanding of modern media publication, because the Court of Justice of the European Union's position seems to be that the internet is a medium rather than a mere technology. In other words, by analogy, a website does not compare to a particular magazine, newspaper, or a particular TV channel, but to print media, TV in general, i.e. the relevant audience being all those who have access to magazines and newspapers rather than access to a particular newspaper, and all those who have access to TVs rather than a specific channel. So from a purely economic perspective, these decisions raise concerns that they open up numerous possibilities to take advantage of copyright holders and content of other parties on the internet. Based on these decisions, it's now possible to use written content, images or videos that are hosted on another website for one's own website simply by embedding them. Apart from using somebody else's internet bandwidth, which wasn't addressed by the Court of Justice at all, the Court of Justice in these copyright cases hasn't taken into account at all what I mentioned earlier, that the embedding the content is actually taking it out of its original context. And as I said, for example, advertisements displayed on the original website alongside the uploaded content on the original website may not appear on the embedding website, and the embedder may therefore spoil an important source of revenue for the copyright owner and use third-party copyright content for its own economic benefit. The most obvious response to these decisions will be that copyright holders will need to protect their content by implementing paywalls or other restrictive measures from the outset. And before I move on to database rights, where the Court of Justice has taken a very different approach, there was actually a further decision of the European Court of Justice handed down 3 days ago involving the low-cost European airline Ryanair that has been in a long-running dispute with various third parties, but one third party in particular, which accessed content on the Ryanair website to enable the sale of Ryanair flights and details about Ryanair timetables and schedules to be available on that third-party website. And interestingly, one thing that the Court of Justice has raised in that decision is that it may be possible for owners of content to bind third parties in contract. But obviously you need to ensure that you are binding that third party in contract by accessing the website, so that even if you cannot sue them for copyright infringement, you may be able to sue them for breach of contract for accessing your content and placing it on their website. But as I say, that decision is a decision of the European Court of Justice that only was handed down 3 days ago, and we still await to see how it's going to be implemented by the referring court. So, moving on to database rights, the Court of Justice has taken a very different approach in the same year as those previous two decisions, Svensson and Bestwater, when it comes to the infringement of database rights. And it's ruled that the use of a meta search engine can, in certain circumstances, constitute reutilization of the contents of a database within the meaning of Article 7.2b of the Database Directive. So what does that mean? Now, I apologize in advance for the detail on this slide. As I said earlier, I know that database rights are an unusual concept, only really common to the European Union, and they provide protection over and above and beyond copyright protection. You don't necessarily need to have original content in a database. It's really protecting the investment that an individual makes in actually producing the database. And that investment can be assessed on a qualitative or quantitative basis. So just to take you through what I've got here, as I say, the Database Directive introduced a new form of legal protection. It's commonly referred to as the sui generis right. And Article 7.1 in particular provides the right for the maker of a database, which shows that there has been qualitatively and or quantitatively a substantial investment in either the obtaining, verification or presentation of the contents to prevent extraction, that's one right you can stop, and or reutilization of the whole or of a substantial part evaluated qualitatively or quantitatively of the contents of that database. Now, for this purpose, Article 7.2b provides that reutilization means any form of making available to the public, so a bit like copyright, of all or a substantial part of the content of a database by the distribution of copies, by renting, online, or other forms of transmission. And Article 7.5 provides that repeated and systematic extraction and or reutilization of insubstantial parts of the contents of the database, implying acts which conflict with the normal exploitation of that database, or which unreasonably prejudice legitimate interests of the maker of the database, shall not be permitted. And the recitals to the directive also back this up. So recital 42 of the directive says that the right to prevent extraction and or reutilization relates to acts by the user which go beyond the legitimate rights and thereby beyond his legitimate rights and thereby harm the investment. The right to prohibit extraction and or reutilization of all or a substantial part of the contents of a database relates not only to the manufacture of parasitical competing products, but also to any user who, through his acts, causes significant qualitative or quantitative detriment to the investment. So, quickly turning to the facts of this case, Wegener operated a website called AutoTrack, which carried car sales advertisements updated daily of about 190,000 to 200,000 second-hand cars, of which around 40,000 were to be found on the AutoTrack website. Now, InnoWeb operated a online car advertising website called Gas Pedal. However, rather than having its own database, it used a dedicated meta search engine, which searched third-party websites, including AutoTracks, using those websites' search engines to obtain results. So when a user typed in search terms on the Gas Pedal website, the site's search engine would translate the relevant command into a language that could be understood by the AutoTrack search engine. The AutoTrack search engine would then find any relevant advertisements and make them available on the Gas Pedal search engine, which would then sort and collate those results from other dedicated search engines on other websites as well. The Gas Pedal search engine would then note where more than one site produced the same advertisement, and then made a single search result of those, presenting the user with links to the multiple sources. For each search performed, the Gas Pedal search engine only returned results representing a small number of the advertisements on the AutoTrack site, but that is because it was only returning results that matched the relevant search terms entered by the internet user. Now, Wegener successfully sued InnoWeb for infringement of its database right, and InnoWeb appealed, and the Hague Court of Appeal stayed the proceedings pending reference to the Court of Justice of the European Union for a preliminary ruling on 9 questions. Now, I won't take you through all 9 questions because the Court of Justice didn't consider it necessary to consider them all. But it did rule that it would be an infringement of the database right to use a meta search engine in circumstances such as that involved in these Dutch proceedings. Under Article 7.1, an operator who makes available on the internet a dedicated meta search engine, such as Gas Pedal, reutilizes the whole or a substantial part of the contents of a protected database, where that database meta search engine 1 provides the end user with a search form which essentially offers the same range of functionality as the search form on the original database site. 2, where it translates queries from end users into the search engine for the database site in real time, so that all the information on that database is searched through. And 3, where it presents the results to the end user using the format of its website, grouping duplications together into a single block item, but in an order that reflects the criteria comparable to those used by the search engine of the database site concerned for originally presenting the results. Just to clarify here, if there's any confusion, a dedicated meta search engine of this type is different from a general search engine based on an algorithm such as that utilized by Google, primarily because a meta search engine does not have its own data itself. It makes use of search engines of third-party websites by transferring the queries from its users to the other search engines, having first translated them into the relevant format required. It therefore offers the public a service where it searches the entire contents of third-party databases or part of them in real time. So Article 7.2b has been broadly drafted to include any other form of making available. And the European Court of Justice has attributed a broad meaning to the concept of reutilization in its case law, focusing on the objective of the database right, which is to stimulate investment in data storage and processing systems. So in light of this objective, the reutilization has been construed as referring to any unauthorized act of making available to the public results from database makers' investments. Accordingly, in this case, it included any distribution to the public of the contents of the database, regardless of the nature and form of the process used. When a website operator makes a dedicated meta search engine available on the internet, it does more than just point out that third-party databases exist that a user can go to and consult. It gives the end user the means of searching all that data in those third-party databases without even visiting those third-party databases websites. And akin to the Svensson and Bestwater case, this might mean that advertisers might stop advertising on the original party's site, or might start placing advertisements on only one database site, or indeed they may choose to move their advertising to the meta search engine site. Now in this case, when looking at the protection of database rights, the European Court of Justice considered this meant that the dedicated meta